All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. We're here for oral argument in case number CR20 0188 State v. Gomez. A couple of housekeeping items before we get started. In more normal times, we would invite you to stand at the podium during your argument, but because these are not those times, today we invite you to stay seated at council table throughout the proceedings. As you can see, our panel is physically distanced, and we have removed our masks to make it easier to communicate with you. If you would like, you are welcome to remove your mask during your argument. Of course, if you feel more comfortable keeping it on, feel free to do so. These proceedings are being video and audio recorded and live streamed, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if you desire. Also, please keep in mind that we've read the briefs and have conferenced the case this morning. With that, counsel, you may proceed.
Thank you. Good morning, Grace Geiswhite from the Maricopa County Office of the Legal Advocate. I'm here today on behalf of Jesus Gomez. As the Eighth Circuit explained in the highly instructive United States v. Rourke, and I quote, "One statement, damaging but isolated, is easily remedied by a limiting instruction. The government cannot, however, in its case in chief, introduce evidence of a defendant's unsavory character merely to show that he is a bad person and thus more likely to have committed the crime. The jury cannot disregard the entire theme of the trial, guilty by association." I start with this quote because I want to make it clear that if the expert testimony had been limited to interpretation of the brief Facebook messages between Clark Wiley and my client, Jesus Gomez, I would not be here before you today. But that is not what happened. Instead, like in Rourke, guilty by association became the theme of Mr. Gomez's trial. Gang evidence dominated every aspect of this case. Over the objection of defense counsel, Mr. Gomez's gang affiliation and the customs and tenets of gangs generally became a theme and was testified to by an expert witness and the state's key civilian witness. This evidence was admitted as substantive evidence without sanitation. The jury repeatedly
How would they have sanitized it? I looked at some of the text messages, and I don't see how you could have sanitized it. I mean, they're referencing, missions and crypts and things like that. How could it have been sanitized?
There's two ways. First, the first judge to have heard the argument on this case had ordered that gang evidence simply not be discussed and that any photographs showing gang signs would be blurred out. In Mr. Gomez's case, when the new judge stated that it would come in, the photographs were no longer blurred out. In terms of the lingo used in the Facebook messages, which again, if it were limited to that, I would not be here, but went farther than the gang Facebook messages. But with regard to that lingo, I think United States v. Abel, the United States Supreme Court case, is informative because in that case, gang evidence was allowed for rebuttal purposes only. And what the court did and what the United States Supreme Court determined made that evidence not unduly prejudicial was not allow the government to use the term Aryan Brotherhood, the name of that particular gang, not allow the government to even use the term gang. They limited it to secret prison organization and did not allow the government to bring in testimony about punishment that could occur to gang members who did not abide the rules of the gang, which the gang expert in this case actually did.
Would you be here, because you've noted you wouldn't be here if it had gone slightly different. Would you be here if the court had said, well, you can't call it a gang, but you can emphasize and testify about or provide evidence about how they're members of a organization or a club or something along those lines?
If it had been limited to the lingo and that sort of sanitation had occurred, I think there'd be, but no, because this became the theme of the case, where the entire closing argument, almost every other page of the closing argument becomes about nutty black Crip gang, Crip mission, Crip business, and
doesn't that, I mean, they argue, and at least their themes seem to promote the idea that it showed motive, opportunity, et cetera, which are all permissible under 404B. So where's your best example of this was being offered solely for purposes of, as you quoted earlier, saying that he was a bad person and therefore did a bad thing, as opposed to showing motive, opportunity, things that are allowed under Rule 404B?
My example comes primarily from the October 17th transcript where the gang expert for 46 pages does not discuss Mr. Gomez. He discusses gang culture generally. He never refers to Mr. Gomez. He instead talks about how gang members are predatory, are violent. And I will skip ahead because that goes to my second point as to how what occurred here was that the 404B evidence that was admitted by the judge then transformed into propensity evidence. And that is where the Arizona Supreme Court has become very clear that there is a line. Profile evidence cannot be used as substantive guilt for substantive guilt purposes, even if it technically would fall under the boundaries of 404B. And so,
Ms. Geisweit, let's stop for a minute. 404B, you don't object to some of the testimony coming in about gangs, gang affiliations, to explain these text messages that are not in common language. Is that what I'm understanding?
there's brief messages. I have a mission on CRIP. I think that in part the defense counsel stipulated to those Facebook messages coming in, and that the purpose of, quite frankly, the gang expert was cumulative to Tiffany Van Ness. But the fact that there was brief testimony about what does "I'm a ride" mean in those text messages, if this was as in work, if that was an isolated incident, I don't think that there would be grounds to argue it was unduly prejudicial. But that's not what this is. What I am specifically looking at is how the state, like in Ketchner, like in Escalante, took this and created a profile of a gang member, customs, tenants. They even went into the details of gang affiliation and what the gangs do, even though Mr. Gomez never objected, even in a pretrial proceeding, that he was in a gang. There was no argument or dispute that he was in a gang, but they turned it into basically a third party of this gang member, unnamed gang member. And then what the state did, and this is why I believe it falls under the reversible error of 404B, Ketchner, Escalante, is because then the state turned it into a theme. And I suppose an analogy that I've considered is, in certain cases, when a defendant takes the stand, which did not occur in this case, but when certain cases, if a defendant chooses to take the stand, the state is allowed to impeach them with prior convictions. However, to avoid that being unduly prejudicial, those convictions are sanitized. They are not allowed to go into the details. But most importantly, and what corresponds to this case, is the state cannot then make those prior convictions the theme of the case. They cannot at closing say, well, you heard that this defendant has committed crimes before, so he must have committed these
but
crimes.
that's because those convictions are only admitted for impeachment purposes.
Which is what the state argued was the primary purpose for the 404B evidence. At pretrial, they said they needed this for rebuttal purposes. But once the judge allowed it in, it became the theme of their case.
Do you concede some gang evidence is admissible to show motive in this case?
Not if it was rising to profile, because specifically what is...
That's not my question. Was some gang evidence admissible in this case to show motive?
Quite frankly, I think because Mr. Gomez did not dispute that he was close friends with Mr. Wiley, because Mr. Gomez did not dispute that he went to Arizona with Clark Wiley, and because Mr. Gomez did not dispute that Clark Wiley had a motive for revenge, it is certainly a close line that this was just used to bolster the case. But as I said in the beginning, if the gang expert had been limited to saying, what does "I'm a ride" mean? Which honestly, if you look at page 42 of that October 17th testimony, the gang expert says, "I'm a ride" could mean I'm going to join you in something, whether it be legal or illegal. That's not exactly a compelling statement as to an interpretation of that text message. But if that had been the limit, but that was not the limit. And I think it is very much like
Again, I'm going to ask again. Will you concede that gang evidence is admissible to show motive? When you have a situation, now you argue maybe it's cumulative with the evidence of being a friend, but is gang evidence admissible to show motive?
I think evidence that what the Facebook messages meant, and if that was they are in an organization together, they have more of a connection to this, but otherwise, no, I don't believe that in this case. I think it is like United States v. Rourke, where that defendant was charged with conspiracy to distribute methamphetamine. And what the government did was bring in testimony about the Hells Angels. And the testimony was about how Hells Angels, people who are members of the Hells Angels, fund themselves through methamphetamine. And the government said, the Eighth Circuit said, sure, we get why that might be relevant. It might be relevant to show this person is probably manufacturing methamphetamine because he belongs to a gang that thrives off of and funds themselves via methamphetamine. But that's too close. And the reason it's too close, and the reason that, to get back to your question, that I don't think gang evidence should have been admitted in this case, is because it ran the risk of being convicted by your associations.
Isn't that a
rather than
403
your
argument, though, as opposed to a 404B argument?
Well, I think the judge went through both in her pretrial ruling, a 401, 403, and 404. She was very brief when she simply wrote, I find that it is not unduly prejudicial. She did not provide any insight into why, but there was a 403 consideration in this case. But yes, as the evidence came in, it became more than just it became profile evidence. And it is similar to the Escalante fundamental error case where...
The reason I asked that question earlier, and I don't mean to belabor this point too much, and I'll let you get back to what you want to talk about, but our Supreme Court has said that gang affiliation evidence can be particularly probative on the issue of motive. And we have a case here where your client said, well, friendship is enough, but I'm friends with lots of people, and I'm not necessarily going to hop in a car and drive across country with them just because they asked. But if maybe there's evidence that I'm in a gang and it's expected of gang members to do these types of retributive activities, that seems to be, just like our Supreme Court has said, probative on why I would be willing to get in that car. So I don't understand where the line is you want us to draw.
Well, the cases that have referenced in Arizona that have referenced how gang evidence can be probative are cases in which they are random and unprovoked attacks, where there is this concern that if the jury is not told as to what the connection is, they won't understand why on earth this person would be there. That is not this case. But what the state does not, they did not in the pretrial proceedings and they do not in the appellate proceedings cite a case that is factually similar where the court has sanctioned the admission of gang evidence. State v. Jackson, which is the case the state relies on primarily in the answering brief, was a case in which the Court of, I believe it was the Court of Appeals, might have been the Supreme Court, stated that the defense introduced the gang testimony. The defense introduced it, and then they also stated, even after the defense introduced it, the only evidence the state brought in was that the defendant was not in a gang, but he was down for them. And that was it. And the court said, under that, we're not going to find that this should be reversed under 404B. That is very different from this case.
So, Ms. Geisweit, let's talk about this case. You object because you say the state turned this into a theme. We agree that gang affiliation could be introduced under 404B to show motive, intent, etc., lack of mistake. We have these text messages that are written in language that is affiliated solely with gang members, as far as I know. I don't know. Maybe it isn't. But so when we give it that, at what point did it become too much? Your client did not object to or admitted being in a gang. Is that correct?
That is correct. He did not object to that.
Okay, so we need to explain a little bit about gang language. This goes back to my first question. Where does the line get too much? Where do we cross the line that turns it from 404B that's authorized and relevant to motive intent to the point where we are all the way over in this becomes the theme and it's guilt by association? Where is that line? Help us find it.
The line, I believe, is when the gang expert transfers from discussing what the brief Facebook messages mean, I'm a ride, mission on Crip, into gang members generally. And what he does repeatedly, and then really where it becomes prejudicial is what the state does, is say they are predatory, they are violent, they are revenge-driven. And as in Ketchner, because I think Ketchner is a good example of where the line is, the gang experts started making this profile gang member match the facts of Mr. Gomez's case. And that's where the Supreme Court said in Ketchner, that's too far, you can't do this, because you're risking that someone is being convicted for their conformity with a profile of a unnamed third-party gang member, and you're matching it to this person, and that they're going to be convicted because of their conformity and not their actions. And that occurs when, and there's multiple quotes that the state repeats that the expert said. The expert tells them, well, the prosecutor actually asked the expert, and he responds affirmatively, so Would an example be if someone wanted revenge against an unrelated person? Yes, that would be an example. They say, are they duty bound to back each other up? They're duty bound. And the expert goes further, and the state repeats it to the jury. If they do not back up another gang member, they will be beaten or killed. This became, the state ends, on page 116, the state ends its rebuttal closing by saying, gangs are about retribution. She doesn't talk about Mr. Gomez. She doesn't talk about Mr. Gomez's actions. And I think with, to just piggyback off of that question, the reason it was had such a prejudicial effect here is because the whole crux of the case was what was the intent when they walked up the stairs to the apartment. That was the only disputed fact. And the judge found that there was sufficient evidence to justify lesser included instructions for second-degree murder and for manslaughter. This wasn't a whodunit. It wasn't a actual innocence case. It was a what was the intent.
Wait, I'm sorry, what is the point that you found? I just want to make sure I'm tracking your argument. So what is the relevance of the judge finding there was sufficient evidence to justify the lesser included instruction?
Because it goes to the fact that there was not overwhelming evidence in this case, that at the end of the day, there was a dispute over what the words versus the actions meant.
I'm surprised by that argument because the standard is pretty much, is there any evidence to support a lesser included instruction? I've never viewed that as a comment on the weight or strength of the evidence by the trial judge. Are you suggesting it is?
I think it is. Well, I think it proves that point, that there was some evidence, and then when you consider it in light of the fact that the jury did not convict him of premeditated murder, that the answering brief got that confused. He was not actually unanimously convicted of premeditated murder. He was only convicted of felony murder, that there is certainly a great possibility or likelihood that the verdict would have been different, meaning that it could have been one of the lesser includeds that was given to the jury had this gang evidence not become the theme of the trial. And if we look at some of that evidence that was not overwhelming, it really does come down to these Facebook message words versus actions. The fact that Mr. Gomez did not bring a weapon. He slept through the ride. Many of the conversations that occur, Tiffany Van West testified, occurred between her and Clark Wiley only. Clark Wiley did not testify, and quite frankly, the brother Alejandro disputes what testimony came in about what Clark Wiley said occurred inside the apartment. They checked Safeway to make sure that the car was there. The neighbor testified that what she heard was knocking and then an argument, and then she heard something that sounded like thuds. We also know that there was a golf club in the apartment that was possibly wielded by the victim in this case. And so there were reasons, and the jury found there was enough reason to not accept the state's premeditation argument, that this could have resulted in a different verdict if the jury had not been reminded at every turn that Mr. Gomez is a gang member. And gang members are predatory, violent, revenge-driven, and duty-bound to back each other up, that they are only out for revenge. And so if they had not been reminded of that constantly, we could be here, or well, we wouldn't be here. There could have been a different verdict in this case. I see that I have a few minutes. If there are no further questions, I will reserve that for rebuttal. Thank you.
Okay, thank you.
May it please the court, I'm Assistant Attorney Alice Jones on behalf of the state of Arizona. This court should affirm Gomez's convictions and sentences because the trial court acted within its discretion in admitting the gang-related evidence for the limited purpose of proving his motive and intent. And it did not fundamentally err when it imposed his sentence.
What I'd like to start with, and it's just so I don't forget. We've got drug courier profile evidence, we have gang member evidence. Draw the correlation between the two, and we've said you cannot present drug courier profile evidence in certain circumstances, and it gets to a certain level and we're done. Where is that level for you? 14 pages of expert testimony?
No, I mean, I think here, I believe because of the Facebook messages and posts, you had to give context. And I appreciate Judge Morris's point that I don't think you can sanitize. Crips were mentioned many times in these Facebook messages and posts. This was a Crip mission. And every time that the prosecutor said that in closing, it's quoting the messages. It's not quoting, this is a Crip mission because the gang expert said Crips would, or, a gang member, a disrespected gang member would go on a mission for that. That was providing, instead, I think the line is, it's providing context for the relationship between Wiley and Gomez and context for the Facebook messages and posts. And when I look at Ketchner and the profile evidence definition, it is, I think the main concern noted there is that you create this profile and you convict someone based on what others do, not what this person did. And that's not how this evidence was used.
But if we start our closing argument as the prosecutor by these are predatory, all of the things that Ms. Geiswhite went over, that's not talking about this defendant. That's talking about gang members in general. So when we look at the theme of the case and the fact that we have all of these generalities being hoisted onto Mr. Gomez, how is that different than drug courier profile evidence? They use this kind of a network to distribute the drugs. They use this kind of a language to do this. They use this kind of trafficking patterns. How is that different? I'm having a hard time drawing the distinction between the two.
I think if it's related to an issue, and I think the Supreme Court's decision in Haskell helps draw that line a little bit too, that there's a distinction between, and I'm sorry, I'm trying to get the, offender characteristics may be admissible if relevant for a reason other than to suggest that the defendant possesses some of those characteristics and therefore may have committed some of the crimes charged. And that's paragraph 17 of State v. Haskell. I think when there's some other relevance besides he's a gang member, so therefore this is what gang members do and this is why he did it. Here it's again always tied to the Facebook messages. And I do think that throughout closing argument, and I disagree, I agree that the state used the Facebook messages a lot in this case, but the gang evidence was always related to motive and intent that was repeated throughout the state's closing. And the words on Crip mission were always based on the Facebook messages between, when Wiley first approached Gomez, it was, I have a mission on Crip for us. And they used lingo that this gang detective who had been a gang detective in El Paso for, I believe he said his gang experience was 18 years, he taught courses on this, could illuminate what these messages meant. And he had to give some context for how he knew that. And the state did have to prove by clear and convincing evidence that for 4B persons that he was a gang member. I think it is important that no profile evidence objection was raised below. That part of this issue should be reviewed for fundamental error. There were no objections to any of these statements in closing. There was no objection when the evidence came in. Prior to trial, the objection was based on the alleged lack of nexus between the murder and the gang membership and the gang activity evidence. And I do want to say, too, that I disagree that this was not sanitized. There was some sanitation to the evidence, and if you look at Record on Appeal 90, the trial court's ruling, it's a 3-page ruling that details that the court should limit the evidence to the murders. It should only limit it to how they know each other through the gang and that they're both gang members, and anything tied to the murder. There were actually messages exchanged about drug activity. I think Molly was referenced, and all of that was sanitized. And the court was clear, you're not going to get into any other gang activities, any other crimes they've committed.
Do you think that the expert's testimony and the extent of the expert's testimony complied with that limitation?
I think, it was always then brought back to the Facebook messages. And I disagree that it was sorry, let me get to my notes here about it. He did testify for 46 pages in a 10-day trial. But all 46 pages of that were not, 40 pages, were not just this evidence. The first, he explained his gang, how he knows about gangs. He explained how he identified both of these individuals as gang members. And when the only general information he gave was why a gang member might feel duty-bound to assist another gang member who's asking him to go on a mission for Crip. As you already noted, Judge Morris, the a friendship relationship does not explain why someone would travel in the middle of the night to states to beat a stranger to death. And I think this is a random random attack as to Gomez. Gomez doesn't know Christian. He doesn't have any relationship with Tiffany. He is a fellow gang member of Wiley's, and that explains why he would go to commit this murder in the middle of the night and travel so far. So I think, again, it was always tied to these Facebook messages and posts and didn't go beyond that line. And I want to say, too, that the court gave a really strong limiting instruction in this case. It actually gave it twice. If you look at the final jury instructions, the transcript on October 24th on pages 11 through 12, it first said the gang, you've heard evidence that the defendant's a gang member. You can only use this for motive and intent. And then it also gave an other acts instruction that the evidence of gang membership and gang activity, again, only motive intent. You cannot consider it as he had a character trait and acted in conformity with that character trait. To the extent that any of this testimony could have come close to creating a profile or suggesting improper character trait evidence, there was a limiting instruction given to the jury, and we do presume that they followed this instruction. And I also want to say that in terms of harmless error, and I did want to address some of the technical errors that were noted in the reply brief, and I do apologize to the court for those errors that were in the answering brief. And I do want to make it clear, we agree that the jury found Gomez guilty only under a felony murder theory of liability, not, I believe only 8 of them found premeditated murder, and he was sentenced for that conviction 25 to life with the possibility of release. But I think for terms of any harmless error analysis, and again, I don't believe any error occurred, but for any fundamental error, prejudice for profile evidence or harmless error analysis, the felony murder theory was based on an intent to commit an aggravated assault. So the underlying burglary, this is different than State v. Ketchner, for example, where burglary was premised on the underlying intent to commit a murder, which is kind of circular a little bit here. And it was very clear to the jury that the underlying felony for burglary was aggravated assault. And
Why do you say that it was very clear to the jury for that?
The state's argument and closing argument was differentiating between premeditated murder and felony murder, and that felony murder is based on the killing Christian during the commission of burglary, which is based on an intent to commit an aggravated assault. And I apologize, I don't have a specific reference for you, but I do know that that's how the state argued it in closing. And I do think that's important because the evidence is simply overwhelming that Gomez had the intent to commit, at the very least, an aggravated assault. After Tiffany and Wiley picked him up in El Paso, they changed clothes to change their appearance. They drove in the middle of the night to Mesa. They were armed with 2 bats. There is a difference in testimony, but the jury could reasonably infer that they went to the Safeway distribution center to see if Christian was there, and when he wasn't, they went to the apartment. They did not have permission to enter that apartment, and they went armed with 2 bats at 3 a.m. And I think Gomez's actions after the murder also are highly relevant to his intent. And again, the teardrop tattoo post is extremely probative of his motive. He's bragging days after the murder that he's now ready for his blue left teardrop tattoo. And the gang expert talked about, and again, this is why this evidence is relevant, that the blue signified Crips and left teardrop meant a aggravated assault or a murder. He's bragging to he's talking about while they're hiding out in Mexico, he's making all these posts, and he's talking about how he may need to go to another state or another country where they can't extradite him. He's bragging. I believe several jail calls were brought in that have a lot of incriminating evidence. So there was, in addition to this evidence, there is overwhelming evidence that he intended at the very least to go into this apartment to commit an aggravated assault.
Can you talk a little bit about the aggravators and the sentencing that happened here?
Yes, and I I also want to clarify, first for count 5, the disorderly conduct, another error. We did cite the correct sentencing statute, but we did list the incorrect ranges. You do need 2 statutory aggravators for that sentence, but here, even with the state's agreement that the deadly weapon aggravator could not be used, you still have 3 statutory aggravators for that, so it's still a lawful sentence. And first, again, I want to again say that this should be under fundamental error review. It's very clear under Arizona Supreme Court precedent that fundamental error review applies. There were several opportunities to object. These aggravators were long noticed by the state. There was an aggravation phase, so this should be fundamental error review. For counts 3 and 4, burglary and conspiracy to commit burglary, just to make clear what the state's arguing, we agree the deadly weapon aggravator could not be used because it was an element of the offense, because the possession of a deadly weapon, and it was presented as a possession of a deadly weapon as an aggravating circumstance. But there's still 4 other valid statutory aggravators that could be used to increase the sentence, and it was only a slightly aggravated sentence, so you only needed 1 to get the range up. Regarding presence of a child, we agree that it's not a statutory aggravator because the evidence is not sufficient for the statutory aggravator, but it's still something that the judge could consider. A judge can always consider the circumstances of the case, and even though it's not a statutory, it's still a valid reason the court can consider to aggravate a sentence. And I would like to say under fundamental error review, Gomez has the burden of affirmatively proving prejudice and cannot speculate to meet that burden. And here there's absolutely nothing in the record that would suggest that he could have received a different sentence. I would draw the court's attention to pages 27 to 30 of the sentencing transcript. And although the court listed all the aggravators found by the jury, it specified the specific things it stressed certain things that it seemed to be moved to give this sentence, and including the severity of the offense, the pain and suffering of the victim's family, and the 12-year-old brother who was present and found 2 men standing over his brother's body. And I think what's also important to note is the court also said it was mindful of the sentence imposed for the co-defendant Wiley. At this point, Clark Wiley had already been convicted and sentenced on the same 4 offenses, and Gomez got the exact same 4 sentences that Wiley did. And the minute entry from that is on April 15th, 2019, and it's the same lower court case number, but with dash 003.
Why is that relevant for us?
Because I think it helps show that the court would not have imposed a different sentence, even if it, even assuming that the deadly weapon aggravator was.
Do we know whether or not the correct aggravators were applied there, or were there other errors there as well?
I do not know that.
Okay, so maybe we shouldn't make that argument then.
Okay, but even without that, I do think that the other things, the severity of the sentence, the 12-year-old witness, those are the things that led the court to impose this slightly aggravated sentence. And then regarding count 5, the disorderly conduct charge or conviction, again, there's 3 valid statutory aggravators, and the court was particularly concerned. This is the conviction that directly related to the 12-year-old brother. He is the victim in that one, and so the court gave the most max aggravated sentence and ran it consecutive to the other sentences, and was particularly concerned about the presence of the child when this murder happened. So again, I just think that even without the deadly weapon aggravator, there's no reasonable probability that the court could have imposed any different sentence in that for that conviction.
Is that the standard?
Well, on fundamental error review, it's the defendant's burden to prove that the court reasonably could have imposed a different sentence. If the court has no further questions, the state respectfully requests to affirm Gomez's convictions and sentences. Thank you.
Thank you.
Thank you. Just to clarify, the Facebook messages were brief. There was one, between Clark Wiley and Mr. Gomez, it was one mission on Crip, and then there was a discussion of I'm a ride in the car. And that was all that occurred in terms of the Facebook messages. And then what happened with the state was they do not, I respectfully disagree, they do not focus on the Facebook messages in their theme. Instead, they repeatedly say, including They repeat the expert's testimony. If a gang member doesn't participate in a crime, Detective Gibson told you they would be punished or even killed. Those are part of the rules of the gang. Revenge is extremely important. Retribution is what gangs are about. That's the closing. That is not at all what was contained in those Facebook messages. And certainly the state took that and then they created an entire profile, and that's what they made the theme. And I think Escalante is especially relevant because that was fundamental error review in terms of the drug trafficking. I would note that the state did not argue fundamental error review. They did concede harmless error because the motion in limine does preserve all of these objections. They do not need to renew their objections. That's the point of the motion in limine. And my footnote in the opening brief lists the Arizona Supreme Court cases that say that. But even under fundamental error review, the Arizona Supreme Court has said, once you start talking about typical behaviors of general people who operate in some capacity, you're too close. You're not actually talking about this defendant, and that's too risky. And that's why the limiting instruction doesn't work in this case.
Are you talking general theme of Escalante in those types of cases, or is that specific language? Because I don't remember a
So the specific
too
language
risky.
in Escalante, the quote is, it was reversed because, and I quote, typical behaviors, the use of typical behaviors of drug traffickers was only relevant to demonstrate that Escalante's behaviors were consistent with drug trafficking. And the same here.
Isn't that the, and I don't mean to belabor this point, but that seems to be the distinction the state urges is that they're not talking about general behaviors, they're talking about motive here. So in Escalante and Courier Profile is on a motive case. So I'm trying to square that circle or kind of link this all together and make sure I understand exactly what you're arguing.
Absolutely. It might be easier to explain very quickly with Ketchner. Ketchner was a motive case because the state argued that Ketchner came into that home to kill the victim. And the defense was that he came into that home high on meth and wanted to sleep with the victim. So the profile evidence directly went to motive. And what the Arizona Supreme Court said, and why the limiting instruction doesn't work in this case, is that you cannot use profile evidence for motive and intent. So what we told them in the limiting instruction here was, you can consider this for motive and intent. But so Ketchner, I think, is more directly on point with regard to motive. I see that my time is up. Thank you.
Counsel, thank you both for your arguments. You've given us much to think about. We'll take the matter under advisement and issue a ruling in due course. And we're adjourned.
Thank you.